a lot of this that I'm going to talk about on briefly, in the next 20 minutes is crimmigration. So I really get into it a lot deeper on my podcast because you just can't do the 6 minutes per case that I do is already about as abbreviated as you can get. I can't do it in 30 seconds. But what matter of Laguerre and matter of Cote have done, at least as I read it, is the board is using it to create a new precedent that I'm not familiar with before. And that's really in the realm of divisibility. As you might know from criminal immigration analysis, a lot of it comes down to divisibility, whether the statute is divisible into crimes or one big crime, because a crime can be committed sometimes in a way that doesn't match the definition of a removable offense. For example, a conviction that can be committed through fraud and not fraud, it's not divisible, it's likely not a CIMT. But if it is divisible, then the court can go and look at some documents and see if the non-citizen committed fraud or not. A lot of this analysis comes down to divisibility, and the board and the Supreme Court have been saying to determine whether a statute is actually multiple crimes rather than just one crime, thereby divisible rather than not divisible. State court decisions determining what are the elements of that offense are the most important thing, or definitely one of the most important things. And in a matter of Laguerre, yeah, but not if the state court decision was published in the 80s or the 90s. Then we really look at it hard, and they're distinguishing old state court decisions in those cases. And don't get me wrong, the board is doing a smart job, and what they're saying does make sense in a lot of ways. But I'm also not familiar with any principle that allows them to ignore state Supreme Court decisions that indicate a statute is not divisible, that things are means rather than elements. And this gets deep into the weeds, and I talk about it on the podcast, but the board isn't even citing to authority either. They're just doing it. So last month they created precedent, and it's for a reason. It might, it seems like it has federalism concerns. I mean, even the Supreme Court defers to state Supreme Court and state appellate court decisions about the elements of state crimes. So it's a big deal. The board did it in January, so I'm bringing it up.
Yeah. So in this kind of situation, I'm guessing this case has to be appealed to federal court to challenge that methodology?
Yeah, and there was a lot of methodologies, a matter of Laguerre and a matter of Cote, and maybe they're right, and maybe they're the correct decisions. But what it does is it creates precedent that allows immigration judges and then the board in the future to ignore other state court decisions that maybe aren't as problematic as the state court precedent in Laguerre and Cote. As to Laguerre and Cote, they would have to be directly petitioned to the circuit courts of appeals where the case originated, and I don't know which ones that is. And I don't know who those attorneys are. I don't know if they intend to do so.
Mm-hmm.
But it's a thing. It's out there. It's the continuous battle that we have over the categorical approach that really all judges seem to hate. And not wrong. I mean, it creates this whole fiction, but it's also it's also immigration practitioners, one of our best tools.
Mm-hmm.
And the Supreme Court has spoken. Supreme Court hasn't spoken that say that, to my knowledge, that the board can do this. So we'll see what happens. It's interesting stuff. I wanted to bring it to everyone's attention.